Good evening, everyone. I'm going to report about liquidated damages. Under Article 2226 of the Civil Code of the Philippines, it defines liquidated damages. Liquidated damages are those agreed upon by the parties to a contract to be paid in case of breach thereof. Nature and concept of liquidated damages. Under Philippine laws, liquidated damages take the nature of penalties. They are identical insofar as legal results are concerned, such that a penal clause, which is an accessory undertaking to assume greater liability in case of a breach, is attached to an obligation intended to ensure the performance of the principal obligation. Thus, liquidated damages are accessory and subsidiary obligations only. Therefore, the nullity of the principal obligation carries with it the nullity of the accessory obligation of liquidated damages pursuant to Article 1230 of the Civil Code of the Philippines. Moreover, liquidated damages take the place of indemnity for damages and the payment of interest. Characteristics of liquidated damages. First, liquidated damages must be validly stipulated for the reason that stipulation for liquidated damages is intended to obviate controversy on the amount of damages. Second, upon agreement, there is no need to prove the amount of actual damages or loss in order that such liquidated damages may be recovered. For instance, an attorney's fee is in the concept of actual damages, except that when it is stipulated and therefore in the form of liquidated damages, then no proof of pecuniary loss is required. Third, the breach of the principal contract or obligation must be proved. When thus liquidated damages may be equitably reduced. Under Article 2227 of the Civil Code of the Philippines, it provides that liquidated damages, whether intended as an indemnity or a penalty, shall be equitably reduced if they are iniquitous or unconscionable. Same with Article 1229 of the Civil Code of the Philippines, which provides that the judge shall equitably reduce the penalty when the principal obligation has been partly or irregularly complied with by the debtor. Even there has been no performance, the penalty may also be reduced by the court if it is iniquitous or unconscionable. In these two articles provided, it implies that if such penalty is excessive, unreasonable, and grossly unfair, and if there is partial or irregular performance of such obligation, then such penalty shall be reduced even if the same has been previously agreed. Relevant provision. Rules governing breach of contract. Article 1226 of the Civil Code of the Philippines states that in obligations with the penal clause, the penalty shall substitute the indemnity for damages and the payment of interest in case of non-compliance. If there is no stipulation to the contrary, nevertheless, damages shall be paid if the obligor refuses to pay the penalty or is guilty of fraud in the fulfillment of the obligation. The penalty may be enforced only when it is demandable in accordance with the provisions of this code. Under Article 1226 of the Civil Code of the Philippines, as a general rule, it provides that in case of breach of contract, the penalty shall substitute the indemnity for damages and the payment of interest, except on the following. First, when there is a stipulation to the contrary. Second, when the obligor is sued for refusal to pay the agreed penalty. Third, when the obligor is guilty of fraud in performance of the obligation. What if the breach of contract committed by the defendant is not the one contemplated by the parties in their agreement? The answer is the court shall determine the measure of damages and not the stipulation agreed upon pursuant to Article 2228 of the Civil Code of the Philippines. Under Article 2228 of the Civil Code of the Philippines, it states that when the breach of the contract committed by the defendant is not the one contemplated by the parties in agreeing upon the liquidated damages, the law shall determine the measures of damages and not the stipulation. Relevant cases. Titan Construction Corporation versus Unifield Enterprises Incorporation, GR number 153874, March 1, 2007. The doctrine of this case is the court shall have the power to equitably reduce the penalty if such is iniquitous or unconscionable. Facts of the case. Titan Construction is engaged in the construction business, while Unifield is engaged in the business of selling various construction materials. From 1990 to 1993, Titan purchased various construction supplies from Unifield amounting to 7,620,433 and 12 centavos, but was only able to pay 6,215,795 and 70 centavos. Unifield sent a demand letter, but the balance of 1,404,637 and 42 centavos remained unpaid. Unifield then filed with the trial court a complaint for collection of sum of money with damages against Titan. The latter did not deny the purchase. The trial court ruled in favor of Unifield, ordering Titan to pay the following: the principal amount of 1,404,114, interest charges in the amount of 504,114, plus accrued interest charges at 24% per annum compounded yearly, reckoned from July 1995 up to the time of full payment. Liquidated damages in the amount of 324,147 and 94 centavo. Attorney's fees equivalent to 25% of whatever amount is due and payable, and accumulated appearance fees at 1,000 per hearing and cost of suits. Then the CA affirmed the lower court's decision. Issue of the case: whether or not the award of liquidated damages, attorney's fees, and interest to Unifield is proper. Ruling the case: no, the Supreme Court held that the attorney's fees stipulated were exorbitant under Articles 1229 and 2227 of the Civil Code, which empower the courts to reduce the penalty if it is iniquitous or unconscionable. Since Unifield was adequately protected by separate stipulation on the balance, liquidated damages, and attorney's fees in case of breach, the court ruled to reduce the attorney's fees to 25% of the principal amount instead of the whole claim. It is allowed the recovery of both liquidated damages and the attorney's fees, even if both were in the nature of penalty clauses. The Supreme Court affirmed the ruling of the CA with modification on the award of attorney's fees. Suatenco versus Reyes, GR number 162729, December 17, 2008. The doctrine of this case is liquidated damages such as attorney's fees stipulated in a promissory note are those agreed upon by the parties to a contract to be paid In case of breach thereof, said fees so provided are awarded in favor of the litigant in the nature of the penalty or liquidated damages, not at compensation for the respondent's counsel. Facts of the case: Congressman Reyes, herein respondent, lends petitioner estimatedly 1.3 million. In the, in the loan contract, it is stipulated that in the event of default, Suantenco must pay the balance plus 12% interest per annum plus 5% attorney's fees for the total award. Attorney Edmundo Reyes, son of the respondent, appeared as the attorney-in-fact of the respondent, files a case for collection of sum of money, the 12% interest and 20% attorney's fees. The lower and appellate courts award the same. However, the petitioner countered, alleging that the stipulated attorney's fee is only 5%. Issue of the case: whether or not the 5% stipulated in the promissory note as basis for attorney's fee is in the nature of liquidated damages. Ruling of the case: yes, the attorney's fees herein litigated are in the nature of liquidated damages, and not the attorney's fees recoverable as between attorney and client initiated and regulated by the rules of court. The stipulation on attorney's fees contained in the said promissory note constitute what is known as a penal clause. A penal clause expressly recognized by law is an accessory undertaking to assume greater liability on the part of the obligor in case of breach of an obligation. The obligor would then be bound to pay the stipulated indemnity without the necessity of proof on the existence and on the measure of damages caused by the breach. It is well settled that so long as stipulation does not contravene laws, morals, or public order, it is strictly binding upon the obligor. The attorney's fees so provided are awarded in favor of the litigant, not his counsel. It is improper for both the RTC and the CA to increase the award of attorney's fee despite the express stipulation contained in the said promissory note, since it is not intended to be the compensation for the respondent's counsel, but was rather in the nature of a penalty or liquidated damages. Thus, the Supreme Court modified the award for the attorney's fee from 20% to 5% of the total balance of the outstanding indebtedness, but affirmed the decision of the appellate court in all other respects. Mariano C. Pamintuan versus Court of Appeals, GR number 26339, December 14, 1979. The doctrine of this case is in obligations with a penal clause, the penalty shall substitute the indemnity for damages and the payment of interest in case of non-compliance, if there is no stipulation to the contrary. Nevertheless, damages shall be paid if the obligor refuses to pay the penalty or is guilty of fraud in the fulfillment of the obligation. The penalty may be enforced only when it is demandable in accordance with the provision of this code. Facts of the case: Mariano Pamintuan was in an agreement with Yu Ping Kun Co. Incorporation to sell plastic sheeting imported by the former from Japan through a barter license he had for the export of white flint corn to Toyo Maikan Kaisa. While the plastic sheeting were arriving in Manila, Pamintuan informed the president of Yu Ping Kun that he was in dire need of cash and requested that he be paid immediately for the plastic sheeting. Consequently, the two parties fixed a price to the plastic sheeting regardless of the kind, quality, or actual invoice value thereof, and based it on dividing the total price of the shipment with its aggregate quantity. After the shipments arrived in Manila, Pamintuan only delivered a portion, or 224 150 yards of the expected 339 and 440 yards of plastic sheeting he received to Yung Ping Kong's warehouse. Furthermore, he delivered plastic sheetings of inferior quality that were valued at a lesser price than what Yu Ping Kong had paid. Subsequently, Yu Ping Kong filed an action to enforce a provision in their contract of sale which states that any violation of the stipulation of that contract would entitle the aggrieved party to liquidated damages in the amount of 10,000 from the offending party. Issue of the case, whether or not compensatory damages may be awarded for breach of contract of sale in addition to liquidated damages stipulated penalty in the said contract. Ruling of the case, yes, compensatory damages may be awarded for breach of a contract of sale in addition to liquidated damages or stipulated penalty in the said contract. Under Article 1226 of the Civil Code, it provides that as a general rule, the penalty takes the place of the indemnity for damages and the payment of interest. However, there are exceptions to this rule under the Civil Code, and one of them is when the obligor is guilty of fraud in the fulfillment of the obligation. Indemnity for damages may be awarded in addition to and apart from penalties stipulated. In the case at bar, the factual findings of the lower courts that Pamintuan was guilty of fraud because he did not make a complete delivery of the plastic sheeting and he overpriced the same is conclusive upon the Supreme Court. Hence, based on this fact, Pamintuan should pay damages. Phil Invest Land versus Court of Appeals, GR number 138980, September 20, 2005. The doctrine of this case is the court shall have the power to equitably reduce the penalty if such is iniquitous or unconscionable, even if there has been no performance. Facts of the case. Petitioner awarded to Respondent Pacific Equipment Corporation development of its residential subdivision, a contract amounting to 12,470,000 pesos. PICORP posted 2 surety bonds to guarantee faithful compliance. Both agreed that liquidated damages of 15,000 per day shall be paid by the PICORP in case of delay. Petitioner claimed that PICORP failed to complete the works and claimed for damages. PICORP, on the other hand, contended that their work stopped due to failure of petitioner to pay for the certain completed portion. The RTC assigned a commissioner to evaluate the claims and counterclaims. The total amount due to PICORP was computed to be 1,881,867 pesos and 66 centavos. Petitioner claimed that liquidated damages amounting to 3,990,000. Both claims and counterclaims were dismissed. Court of Appeals affirmed the ruling of RTC. Issue of the case, whether or not the penalty or liquidated damages of 15,000 per day of delay shall be binding upon mutual agreement of parties. The ruling of the case. No, as a general rule, courts are not at liberty to ignore the freedom of the parties to agree on such terms and conditions as they see fit as long as they are not contrary to law, morals, good custom, public orders, or public policy. The judge shall equitably reduce the penalty when the principal obligation has been partly or irregularly complied with by the debtor. Even if there has been no performance, the penalty may also be reduced by the courts if it is iniquitous or unconscionable. The penalty interest of 15,000 per day of delay has liquidated damages or 3,990,000 representing 32% of penalty of the 12,470,000 contract price is unconscionable considering that the construction was already not far from completion. Bar questions. 1994 bar question. On January 5, 1992, Nonoy obtained a loan of 1 million from his friend Rafi. The promissory note did not stipulate any payment of interest. The note was due on January 5, 1993, but before this date, the two became political enemies. Nonoy, out of spite, deliberately defaulted in paying the note, thus forcing Rafi to sue him. Can Rafi ask for attorney's fee? Suggested answer, yes, under paragraph 2, article 2208 of the Civil Code, considering that Noynoy's act or omission has compelled Rafi to litigate to protect his interests. Furthermore, attorney's fees may be awarded by the court when it is just and equitably